the Constitution does not confer a right to abortion. That's what Justice Alito and 4 other justices agreed to. That is gigantic. Roe and Casey are overruled. That is also gigantic. Casey's controlling opinion skipped over the question and reaffirmed Roe solely on the basis of stare decisis. Stare decisis is sometimes wrong. It was here. Just like in Plessy versus Ferguson, just like in Karamazov. What that means is sometimes the Supreme Court got it wrong, and they got it wrong for 50 years. What is personally gratifying is that we've been litigating this issue for almost 40 years. I'm going to hold up a picture of American Lawyer magazine. It's a picture of me in 1991 with Randall Terry, the head of Operation Rescue. They were doing these rescues all over the country for the unborn. The case went to the Supreme Court of the United States, Bray versus Alexandria. But what's interesting about this is that Operation Rescue, Randall Terry, Pat Mahoney, others, Janie Bray, led a movement that changed, as Jordan said, the face of the entire abortion debate. In the 1980s, there was a huge pro-life movement. It was started with the Summer of Mercy in Omaha, in Tulsa, Oklahoma, all over the country, Atlanta. And we represented Operation Rescue. It was very controversial at the time. They were engaged, as Jordan said, in acts of civil disobedience, means they blockaded access to the abortion clinics. The judges were issuing restraining orders and injunctions all over the country trying to shut these activities down. Tens of thousands of people participated in these. I mean, tens of thousands of people. And we had the opportunity to represent them. And it was, I will tell you something, originally I went into it thinking I wasn't going to do it. And circumstances, as I was going into the jail in Atlanta, it was very clear to me that I was supposed to represent Randall Terry and the leadership of Operation Rescue before the Georgia Supreme Court, the Texas Supreme Court, federal courts in New York, federal courts in Nebraska, federal courts in Oklahoma. I mean, it was massive litigation, California. And these cases really brought the attention of what the life movement was all about. But the advocates against life were utilizing the Ku Klux Klan Act of 1871 to stop these protests. And then the abortion proponents started using the 14th Amendment Equal Protection Clause as a basis to basically say that there's this unlimited right to abortion. And I argued twice at the Supreme Court, 1990 and 1991. And my co-counsel argued the case twice as well. My co-counsel in the case was for the United States government, the Deputy Solicitor General of the United States. It was under the Bush administration, under George W. Bush. That's how long ago this was. And they argued in our favor, saying that the Ku Klux Klan Act could not be applied this way, that it was a violation of the Ku Klux. Applying it that would be a violation of First Amendment principles. My co-counsel in the case, or the counsel for the United States government on our side, was the Deputy Solicitor General of the United States. His name was John Roberts. He's now the current Chief Justice of the United States. We argued the case together twice. It was very important in that case because the court concluded that opposition to abortion was not discrimination against women. And since these abortion advocates were utilizing the 14th Amendment, the Equal Protection Clause, as a basis to do this, this became very important. And when you get to the first substantive legal discussion in the opinion today in Dobbs overturning Roe versus Wade, the court starts the paragraph by saying, we discussed this theory, because this was a new theory that they started using to justify abortion. They said the one additional constitutional provision that respondents have now offered as yet another potential home for the abortion right, the 14th Amendment. And then they cite the briefs that were filed for that, including the United States government now under Joe Biden, which thought there was this right. But here's what the court said. The court disagreed with that on page 9 and 10 of its opinion, 10 and 11. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination against members of one sex or the other. As the court has stated, the goal of, quote, preventing abortion does not constitute, quote, invidiously discriminatory animus against women. The case is Bray versus Alexandria Women's Health Clinic, our case from 1992 and 93. Accordingly, laws regulating abortion or prohibiting abortion are not subject to heightened scrutiny. And what that means is rational basis applied. The court concluded that rational basis, you can protect the life of the unborn. It returns to the state. There was no constitutional home for the right to abortion in the 14th Amendment. Bray versus Alexandria. Opposition to abortion is not discrimination against women. Who would have thought that a case we argued in 1991 and again in 1992, decided in 1993, based on activities that took place in 89 and 1990, would end up as the basis, one of the bases for this critical Supreme Court decision. But there it is. I don't want to get emotional on this, but I am going to say that your support of us all the way back then, and we were a much smaller organization. We had a handful of lawyers. But look at the result that God gave in a case like this. So to me, it's particularly gratifying for all of us at the ACLJ, and it's a great opportunity for us to thank you.